Imagine you're on a remote vacation and an unexpected accident leaves you incapacitated. Back home, urgent financial, medical, and personal decisions need to be made. Who steps in if you can't? That's where a springing power of attorney becomes essential. In this video, I'll cover everything you need to know about the springing power of attorney, including what it is, who should consider creating one, challenges to consider, and whether an attorney needs to draft it. It's important to note that a springing power of attorney often forms part of a more comprehensive estate plan, which might also include a will, revocable living trust, durable power of attorney, and advanced healthcare directive. If you're interested in learning more about these other important documents, I've made more in-depth videos on each of these topics. I'll share links to those videos in the description below. Unlike a durable power of attorney, which grants immediate authority to the appointed agent, a springing power of attorney only takes effect under specific conditions predefined by the creator, such as medical declaration of incapacity. This delayed activation ensures that authority is only transferred when absolutely necessary, protecting against premature or inappropriate use of the power when the principal is still capable of managing their own affairs. This level of customization allows the springing power of attorney to be a highly flexible tool that aligns closely with an individual's specific needs and desires, providing rigorous protection of their rights and assets on their own terms. A springing power of attorney is particularly suited for individuals who are currently in good health but want to plan for unexpected illness or disability. It can also be an excellent tool for those who are concerned about providing premature control over their assets and prefer a safeguard that ensures that their power of attorney only takes effect when they are truly unable to manage their own affairs. One of the key challenges with the springing power of attorney is identifying the exact moment when the principal becomes incapacitated, which can result in delays and disputes when swift action is necessary. Defining incapacity typically requires the assessment of qualified medical professionals who must determine whether the individual can no longer manage their personal and financial affairs. The criteria for such determinations can range broadly from signs of cognitive decline like dementia to a physical inability to communicate. Without clear, predefined conditions in the power of attorney document, these determinations can become ambiguous, leading to disagreements about whether the principal meets the established threshold of incapacity. Moreover, the process of obtaining medical evaluations to confirm incapacity can be lengthy, potentially delaying critical decisions regarding the principal's health and finances. This can be particularly problematic in emergency situations, adding stress and uncertainty. Additionally, the effectiveness of a springing power of attorney depends significantly on the choice of the agent. An agent who is unprepared, lacks a deep understanding of the principal's preferences, or is unable to act decisively can undermine the intent of the power of attorney. While I always recommend speaking with an attorney for complex or highly personal situations, an attorney isn't always necessary. For many people, online platforms are a smart way to create legal documents affordably and efficiently. That's why I've partnered with trusted names like Trust & Will, Nolo, LegalZoom, and Rocket Lawyer to make estate planning more accessible. You'll find those affiliate links below, and using them helps support this channel at no extra cost to you. These online tools allow you to create essential legal documents from home, quickly, affordably, and on your schedule. Take control of your future. Start creating your springing power of attorney today.